How to successfully represent yourself in the courtroom and win the judges and jury's admiration. If you're involved in litigation, it's better to reach out to a professional to defend you. But if the case isn't too complex or relates to a small claim, or money's just too tight on your end, you can take matters in your own hands and represent yourself in court. When push comes to shove, here is how to properly play the self-representation card so you can make a good impression on the judge and jurors and potentially win your case. Welcome back, folks, to another edition of Sweetie Kiwi. I'm very happy to have you today. I hope you are doing marvelous. I'm doing fantastic. If you were to ask if you're doing as great as I am, go grab a cup of coffee or tea. But let's roll. Today I want to talk to you about a very important element: how to successfully represent yourself in the courtroom and win the judges and jury's admiration. The first thing you got to do is to meet the deadlines. Very important. When it comes to court matters, there is a specific calendar that every court has, and what you want to do is you want to pay attention to the court calendar. There are some necessary papers that you need to file before beginning a lawsuit, and it's very important if you have to request a jury trial or a court trial in front of a judge. You need to also follow what the court wants in terms of fees if you have to make some payments. Remember, it's very important that those deadlines have to be followed strictly. Just because you are representing yourself doesn't mean that the judge will give you any leeway, right? Because if it's a matter of compliance, it's a matter of etiquette. So if you miss a crucial deadline, this could result in a monetary sanction. It could also result in the fact that the judge will reject you presenting some kind of evidence or testimony, or your case could outright be thrown out of court. So it is very important to understand that court business is serious business. All right, so meet your deadlines. Number 2, decide what you want. Do you want a jury trial or a judge trial? Right? It really depends on the case, and it really depends on the court. It depends on the state and city where you are. Certain types of cases can be heard only by judges, right? I'm talking about small claims cases, for instance, right? Now, either way, remember that either party has the right to request a jury trial. So you might want to have a court trial, a judge trial, that is, but the other party might want a jury trial because they probably believe they have a better chance of winning. So an attorney will usually choose a jury for a sympathetic case and a judge for a case involving complicated law or disturbing facts. This is what the legal tradition has been. Now, it is very important because attorneys believe that a judge is in a better position to apply the law in an objective manner, right? So think about that. It's very important that you really think about that. Now, when it comes to a jury trial, there's something called voir dire process. That's basically a legal term that relates to the selection of jurors potential jurors during litigation. Now, the prosecution and defense have the opportunity to remove potential jurors whom they don't want on the jury. All right, so prosecutors and defense attorneys can use an unlimited number of calls, quote-unquote call challenges, to eliminate jurors who aren't qualified, able, or fit to serve in the case. So if you use a cause challenge, the lawyer trying to remove a juror must give a reason to believe the juror won't be able to reach a fair verdict. Now, the reason why I'm bringing this here is that if you want to go to jury, if you want to have a jury trial, just think about the voir dire process, and that there are cases where the defendant's attorney might invoke some kind of cause challenges to eliminate jurors that you might have chosen. So it's very important to have that in mind. The third thing you want to think about is respect. You got to follow proper court etiquette. You have to be courteous in the way you address the court. You have to address the judge as Your Honor, right? Not Mr. John Doe or Judge John Doe or Judge Jane Doe. It's Your Honor. You have to, and this is very important because Court matters can be very controversial, can be very hectic, can be very stressful. So you need to have a minimal respect in the courtroom, and that will really increase or improve your reputation also vis-a-vis the court. So showing respect for people and procedures in the courtroom will help you gain the respect of the judge, right? And this will make your day in court a more pleasant and more enjoyable experience, if I can use the word enjoyable, right? So the first three things you want to think about is to meet your deadlines, decide what you want, jury trial or judge trial, and the third thing is be respectful. I'll be right back right after this. Do not go anywhere. Welcome back, folks, to another edition of Sweetie Kiwa. We're still having a conversation today around how to successfully represent yourself in the courtroom and win the judges and jury's admiration. And let's continue the conversation. If you like the content's clarity and quality so far, please consider subscribing to our channel and turning on the notification bell so that you are informed whenever we drop a new show. And we do this every single day, actually. And consider also sharing this content and liking it, commenting below. Have you ever represented yourself in court? Let us know the ins and outs, how your experience was, and what you can advise other people who are contemplating this kind of option. Let them know what they want to have. The next thing I want you to think about is you need to familiarize yourself with your case. It's very important to learn the fundamentals of your case, to know the elements, the necessary elements. You'll never win a lawsuit by just getting to the courtroom and just asking money from your opponent, right? So you want to have, in law, there's something called each legal claim has several elements that you will need to prove, right? So it's most of the time, it's all or nothing proposition. So if you fail to prove an element, you will lose, right? So, for instance, let's say that you are on a contract dispute, right? You must not only prove that a contract did exist, that you held up your end of the bargain, that your opponent failed to meet his or her contractual obligations, and that you were harmed as a result, right? So there is a chain of causes, there is a chain of elements you need to prove to be right in court. So it's very important to do your homework beforehand so you understand what it takes to win, right? Now, the thing here is that you also need to understand what it means when people talk about jury instructions, right? Those are simple statements of the law that the judge will read to the jury so the jury knows the element that you must prove to. Right now, again, this show is not about providing legal advice. This is very important to this is an important disclaimer here. We are giving general information, and each person's situation is different. If you require legal advice, it's better to reach out to a legal professional, a lawyer, an attorney, or if you choose to take things in your own hands, then you want to do the research and you really want to be responsible for anything you do. We are providing general information here. So what I was trying to say here is that each state has a set of civil and criminal jury instructions. So to prove your case in court, you got to follow the legalese. You got to follow the legal instructions in your area, in your city, in your township, in your locality before going to court. Number 5. Present only evidence that's admissible. Now, it's very important. You might have gazillions of evidence there, but some evidential items are not admissible in court, right? You have to know the element. Once you know the element of your case, you will know what you have to prove to win your case, right? Now, as I said earlier, for instance, there are when it comes to court procedures, there are some complex and often convoluted rules of evidence that determine whether a particular document, statement, or item is admissible in court. All right. Now, the idea here is not to be a lawyer and master or understand every details of the rules, but you got to do research enough to make sure that you are presenting evidence that the court will admit and that can help you win. All right. So when it comes to the legal jargon, they talk about chain of custody for evidence, right? This is chain of custody typically refers to the foundation the prosecution needs to establish for certain types of exhibits to be admitted into evidence, right? Because you can present something, but if the court strikes it down and the court does not allow it to be admitted into evidence, this will not go towards allowing you to win, right? It won't be in the records, right? There's another element you need to pay attention to here is the defendants and character evidence, right? So, defendants can offer evidence of their good character, but this sometimes comes with certain risk. So it's basically a case-by-case approach. You have to really see what works for you. There is also another concept called evidence of prior convictions, right? So admissible. So basically, when any witness, including a defendant, testifies, his or her credibility is at issue, right? So the fact finder, either the judge or the jury, must decide whether and how much to believe the witness. So any witness that you call to the bench, you want to make sure that the witness's credibility is polished, is clean, it is perfect. I mean, nobody's perfect, but you want to make sure the person doesn't have a heavy past, criminally speaking or legally speaking. The next thing you want to do if you want to win your court, if you want to win the judges and jury's admiration, is to never interrupt a speaker, right? This sort of harks back to my earlier comment about court etiquette, where you want to be on time, where you want to respect the deadlines, where you want to be polite, you want to be respectful, right? Sometimes, if you look on TV, if you watch on TV, it can be very complicated to sit around on a bench and, while your opponent or your opponent's lawyer or the judge himself or herself makes light of your argument and, or implies that you aren't telling the truth, right? And the first reflex is to just jump off and say, listen, no, I'm telling the truth. No matter how anxious or frustrated or angry you are, you should never interrupt, especially the judge, right? The thing is, because courts have their own procedures, you'll get a chance to tell your side of the story, right? It's very important. So always keep your cool. Always keep your cool. As a general rule, you probably have noticed this yourself. Quiet people, calm people are more believable, right? People ascribe more credibility to them as opposed to folks who are always agitated or restless. All right. So use nonverbal communication to also convey to the court that your case, you have a solid case and you're comfortable that you're going to win. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweaty Keyword. We're still having a conversation today around how to successfully represent yourself in the courtroom and win the judges and jury's admiration. Just want to give a quick shout out to our millions of fans and listeners in the United States and over the world. We acknowledge our listeners and viewers in Africa. We have Congo, Nigeria, South Africa. We have viewers and listeners in Europe. We have Germany, France, UK, Italy. Also remember our viewers and listeners in Australia, in Japan, in China, and of course in the United States. We really appreciate your loyalty. Next thing you want to do is to prepare a trial notebook. Now, trial notebook is very important. It is basically a blueprint for the trial of the case, right? And I'm talking about from the voir dire process through the court's charge. So the goal of the trial book is to use it in a very strategic way, so that the blueprint is being completed as the litigation progresses, right? So during a trial, if you self-represent, you probably testify or you probably question witnesses, both those who support you and those who support your opponent, right? So you got to present argument to the court about why you should win the case, right? So it is very important that you monitor the questions you want to ask, that you highlight the fact that you have to prove to win the case. You want to make a strong argument. So this is very important. If you do these things go into in a trial notebook, All right, so you can do that. Now, trial notebooks can be very simple or complicated. Sometimes if you are representing yourself and you're a newbie in the legal world, you can use a simple 3-ring binder with tabs for each section. Now, if you want to go deeper, you want to use the trial notebook of a professional attorney, an experienced attorney, you can go as high as eight tabs. For instance, you have the voir dire process, the opening, the witnesses, the exhibits, the closing, the charge, the law, and miscellaneous. Next thing you want to think about is you want to watch some trials and learn the ropes. It's very important. Nowadays, fortunately, you don't have to go to a physical court, but I would strongly advise you to go to a physical court. Just kind of have the look and feel. It's not the same thing as just sitting on your couch and watching Judge Judy or any other court-related show, right? The thing here is that you want to watch some trials. You want to immerse yourself in the environment, in the court environment. You want to pay attention to the procedures, the rules, how the judge talks, how the defendant talks, how the parties talk. You want to understand, all the nonverbal communication, all the verbal communication, everything. And you got to learn the rope. Got to learn the ropes. Very, very important. Yeah, you have to understand, you're not a lawyer. You want to represent yourself. Lawyers spend years and years and years learning how to question witnesses, present evidence, and make arguments in court. Right? So don't expect that what someone has learned over 10 years or 15 years or 20 years, you can do this in 1 month or 2 months. So you have to work double, triple, quadruple. You got to work harder to be able to not master, but at least understand the ropes. You have to understand, if the other party has an attorney, he or she is going to literally be hard on you. They're going to push you hard. And that's just fair. That's how things goes in court. So you got to prepare too. This is very important. Which leads me to my final point here. Stand your ground. Stand your ground. You want to assert yourself. If you find yourself up against a lawyer who won't stop just attacking you or won't let you get a word in edgewise, you have to stand your ground. Don't let yourself be intimidated because somebody's using some kind of legalese and trying to confuse you. Doesn't matter. If you have done your homework thoroughly and you understand the strength and the legal foundation of your case, you can make your point in court, confidently and not waver, because lawyers use sometimes this sort of tactics to sort of scare. They want to scare the opponents. But it's okay because the judge can see through that. Judge will understand that as long as you're polite to the judge and the court in general, you're following the rules, you are being on time, you are complying, the judge can understand. You have to tell the judge why you are representing yourself. Like, money is too tight, you're having financial problems, or you just decided. You got to come up with a real reason, right? Because the judge wants to make sure you're taking your own case very seriously, that if you don't have an attorney, it's because you cannot afford one, or you are in some kind of incapacity. But you got to make your case to the judge. But once you do this, the judge will make an effort to keep the proceedings comprehensible to you as a self-represented party, and take steps to rein in an opposing lawyer who tries to take an unfair advantage. What I'm trying to say here is that if the judge realizes that you are honest and you are coming from a right you have explained things thoroughly, the judge will make sure that the playing field is leveled, and that's very important. All right. Thank you so much for listening to me in today's conversation. I really appreciate it. If you enjoy the quality and clarity of today's show, please consider subscribing to our channel and turn on the notification bell. I want you to also smash the like button. Share this content if you believe there are some people who are in a situation right now where they might need this type of advice. Please share. Comment below. Let us know your experience when it comes to self-representation, and let us know also whether you have ever won a case by representing yourself. And just want to recap what I spoke about today: how to successfully represent yourself in the courtroom and win the judges and jury's admiration. You want to meet the deadlines. You want to decide what you want: jury trial or judge trial. Be respectful. Familiarize yourself with your case. Present only evidence that's admissible. Never interrupt the speaker. Prepare a trial notebook. Watch some trials and learn the ropes. Stand your ground. All right? Good luck. I will see you next time, and until then, stay marvelous.